that's usually the way it is.
Yeah.
They have very specific questions. I don't care what you have to say.
Yeah.
I want the answer to my
Yeah.
question, period.
Yeah.
Kind of, yeah. Yeah. Oh, you could definitely see which way it was going, which way. And I love to watch versus and the judges, when they get that crank back thing, and
Yeah.
they're just like rocking.
Judging, sometimes I'm like, please lean into the microphone.
I know. I had one of those in state court, and he was not so far, he couldn't really sit on the bench, because he just like so cranked back. He's like, that's what
Like,
they say,
nervous
Joe.
to do that.
Stop.
And the governor also and Steve saw it as well. Leaning on this side and see what he noticed. On it. Yeah, go to the main chat and you can type what the name is and we'll be watching.
Mm-hmm.
That's what it is. Nicole and I have the screen.
No, I've not heard of it, but I've been the computer crash yesterday and made the judges, I like that better, because I could see all the judges. I don't need to see the names,
Yeah.
I get to see the judges. They're so small.
Yeah, I agree with that. I think there was reason, you know, to be on them better.
Yeah.
It's nice to see them just, but if we're gonna do it, it's and not handing where we're seeing those photos.
Right.
Yeah, and the timer does not need to be. If you're in this
No,
audience,
no,
you
I
don't get
agree.
to see the timer.
No, so why should you over there?
Yes. Well, I sent a message to them, they don't even know what that is. They want to time too, but I hope that forgot.
What? Yes. The second case? Is there a Mr. Calandra? Caliandra? Oh, goody. No, I'll do a roll call, but apparently the other side on the first case is not checked in yet. So they're looking for him. Oh, now somebody else is saying he's here. Okay. I don't see a check by his name. All right. He just checked. I know Nicole messed with the camera a little this morning to make sure it wasn't blocking Judge Niemeyer's view of the clock. Oh.
No?
Uh-uh. Yeah. You talking about the zooming in on the judges?
No zooming in on council.
Oh, I was thinking the judges. Looks the
Yeah,
same.
I don't
Okay.
know. Zoom. Her and Nicole did that yesterday.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear is Defoe versus Ionic, and Mr. Calandra, we'll hear from you first.
Good morning, Your Honors. Brian Calandra, Pomerantz LLP, on behalf of the plaintiffs, and may it please the court. As Your Honors have seen in our papers, the parties have briefed a plethora of issues in this securities fraud class action, but this panel need only reach one issue, the question of whether defendants IonQ and certain of its executives and certain executives of a special purpose acquisition company that ultimately merged with IonQ, that their misrepresentations caused my clients, the plaintiffs, losses. And we submit that the Scorpion
And
short seller
your
report-
client is a short seller, right?
I'm sorry, Your Honor?
Well, the Scorpion LLC is a short seller.
That is correct. And Scorpion Capital authored a short report based on an internal investigation with 25 interviews, of 7 of which were with former employees, 11 experts, and 5 customers of the company.
And that report, accurate or not, could cause them to make a lot of money.
It could cause it. They were short, that's correct. But short sellers, just at the macro level, play a valuable role in the securities markets because they are incentivized to go out and see if companies that are not necessarily vetted, and in the case of special purpose acquisition companies, really hardly vetted at all, are being genuine with the marketplace. And in this case, they found quite readily, and in ways that we were able to corroborate in our own investigation, that defendants here were not being genuine with the marketplace and were trying to sell the marketplace on technology that did not exist. And even though Scorpion stood to profit, the profits that Scorpion stood to make probably paled in comparison to the profits defendants stood to make, to the tune of hundreds of millions of dollars if this SPAC merger successfully closed. And Your Honor, you can see in your sister circuits that other than the Ninth Circuit, and we can go into why I think the Ninth Circuit's decisions are distinguishable, these kinds of short reports are routinely credited, whereas here they're based on a special investigation that's not of information that's not immediately available to those inside the company, or to the marketplace in general, I'm sorry, based on information that could not be readily ascertained by the marketplace in general. They talk to former employees, and they talk to experts. And this is the kind of short report we have here. So to basically—
How many of those are a short report where the short reporter says, we cannot and do not provide any representations or warranties with respect to the accuracy of these materials. We cannot and do not provide any representations or warranties with respect to the information provided to us.
Your Honor, every single short seller report, every single one carries that disclaimer.
Is that in the record?
We have tested it in our papers, and if you'll see in Lee v. Tal, a Second Circuit case at 837 F. 3rd 20, which sustained in a loss causation context, a Muddy Waters was the name of the short seller's short report.
Wait, you said it was in your papers. The question was, is it in the record?
We have not submitted an exhibit showing all of the short reports out there and all of the disclaimers that are attached to those short reports.
So that's a no, it's not in the record?
Your Honor, well, yes, it is. We do not have such an exhibit in the record. But even
Okay.
defendants do not dispute that these kinds of disclaimers are present in every single short report in the market. And even the district court acknowledged—
Does that make a difference? Don't we accept the words for what they mean?
Your Honor, just because, we look to how other courts
I mean,
have treated.
it's almost as if a short report is attempting to manipulate the market based on evidence or statements that they don't want to back up with any assertions, so they have all that disclaiming language. But
Well-
the long and short of it is the person reading that understands that the short report person is going to make money if the market goes down.
And, Your Honor, taking what you said, in this particular case, if that were true, if the short report was enough on its own and investors would disregard it because they know that Scorpion Capital is making money, why
No,
did
they wouldn't disregard it. They may accept it and knock the market down. The point being is they could be saying anything. The market, the people who purchase may not take those disclaimers, read the fine print in detail. But the long and short is that the short report clearly intends to tell the public that the statements made by Ionic is puffery or crazy or whatever you want to call it.
falsities, material misrepresentation.
Well, that's your allegation, you're right.
But, Your Honor, now, this is an important distinction to make. What you are getting at is a question of whether the report is credible, based on the fact that it contains a disclaimer.
Can I
But
ask
that,
you just another question, collateral,
course.
that's bothered me along the other lines? Did any of the plaintiffs sell their shares?
my clients,
mean,
or
on the
certain
record.
class members sold shares after the Scorpion report came out, yes.
In the record, some of the plaintiffs sold?
It's not in the record before this court, but it is in the record before the district court. But also, Your Honor.
Well, no, tell me about that. You say somebody sold, when did they sell?
They sold in the weeks after the Scorpion report.
Is that what's alleged or shown?
That is, Your Honor, in the context of a
I
securities.
couldn't find it, that's why I'm pressing you.
Right.
I'd like to know whether the plaintiffs acted, in other words, actually sold shares when the market was down.
In the context of a securities class action, the plaintiffs are not obligated to.
I didn't ask you that, did I? I asked you, where's the record did the plaintiffs show that they've sold?
In the district court, in our lead plaintiff motion, we show the purchases and sales of IonQ stock during and I believe shortly after the class period.
Is there any evidence to support those?
In order to be appointed lead plaintiff, you have to provide proof of your.
I didn't ask you that either, did I? I said, is there anything to support it?
Well, my clients have trading records.
Were they in the record?
They weren't required to submit them at the time they
I
filed
didn't
the
ask you whether
case.
they're required. I'm asking you, were they in the record? You know, these questions aren't too hard. You're very defensive about them. We can take the next steps, but it's good for us to have an agreement, what's in the record and what's not. This is a summary judgment record, and we act on the record. And so
Respectfully,
my
Your Honor,
question
this
to
is a motion to dismiss record. But I take your point, Judge Niermeyer. And to answer your question, no, the proof of my client's purchases and sales are not in the record before this court.
So the district court, in both opinions, said that the complaint had not sufficiently alleged loss causation, which is a specific required element. Why don't you give us your best explanation as to why the court was wrong?
Certainly, Judge Agee. Under Singer, which, Judge Agee, you were on the panel for, the plaintiff must allege the exposure of the defendant's misrepresentation or omission and the relevation of new facts suggesting the perpetration of a fraud and that such exposure resulted in a share price decline. And that's it. There is no requirement of the credibility of the disclosure. In fact, this court has held in Singer that a disclosure can take
But
any form.
that seems to say, it's a plaintiff, I can plead loss, and that's the equivalent of pleading loss causation.
Not exactly, not necessarily, Your Honor. For example, some courts have found that because there are multiple disclosures going on in the marketplace, a specific disclosure can't be separated and is not sufficient to show loss causation. But here we have additional facts. We don't just plead that this came out and the price fell, which under Singer gets us most of the way there. We
So
also
what are
plead.
those?
I'm sorry,
What are
Judge.
those additional facts?
Yes. We have 4 articles that came out in response to the Scorpion report saying the stock price had fallen. 3 of the articles say after or following, and the 4th says the Scorpion report is helping drive a 10% decline in the stock. And then most importantly, defendants came out and issued not 1, but 2 releases to try to stop the decline of the stock. Now, Judge
So
Niedermeyer.
what's wrong with that? I mean, isn't that a pretty natural thing to do?
It's a sign that investors were reacting to the Scorpion report.
Well,
And
once
that the
again, it almost seems like to me you're back to saying, I can plead there was a loss, and that's the equivalent of pleading that there's loss causation. I mean, it's a fine point, but the element that has to be alleged and then proved is loss causation.
You are correct, Your Honor. And in Singer, as you'll recall, there were 2 disclosures. One was of a subpoena sent to the defendant company, and the other was an analyst report saying this subpoena is probably looking for legal violations. Not definitely, not conclusively looking for legal violations, but probably looking for legal violations. And we have effectively something analogous to that, where we have a short report saying, we have investigated this company, and this company is lying or is making misrepresentations about its technology. And we have market watchers reacting and saying, look, this is because this short report came out and because of what was disclosed in the short report. If you look at the Quantum Insider article, which defendants and the district court mischaracterize as attacking the Scorpion report, it isn't attacking the
You
Scorpion
know,
report.
I've read that several times, and that doesn't seem to be too far off.
No, if you look, Your Honor, especially towards the 4th paragraph of the article, where it talks about how what IonQ appears to be, what Scorpion appears to be accusing IonQ of is exaggerating. That is,
Not a
They don't say one way or the
particularly
other.
helpful analysis.
I'm sorry, Your Honor?
I'm quoting from the report, not a particularly helpful analysis.
That dealt with one specific aspect of the report, the question of whether asking a quantum computer to add 1 + 1 and 2 + 3 was helpful. But that is the only critical part of that report. The rest of the report, especially as to claiming you have technology you don't have, which the report cautioned was an issue amongst these startup companies in the quantum space, as well as...
Which paragraphs in your complaint do you think best support loss causation?
Your Honor, they are, and would you prefer I refer to the original complaint or the proposed second amended complaint?
The operative complaint, second
That-
amended.
Exactly.
Those paragraphs are...
And tell us where you are in the appendix.
Yes, of course, Your Honor. They are... beginning on page JA 1054 at paragraph 233 and running through page JA 1057 at paragraph 240. We describe the publishing of the
Wait,
Scorpion report.
10 or 01?
10. It
Okay.
is, I'm sorry, Your Honors, it is JA 1054, paragraph 233,
Okay.
to JA 1057, paragraph 240.
Oh, where it starts, the truth emerges.
That's correct. The truth emerges is our loss causation allegations.
All right.
And I will point, Your Honors, to pages JA 0704 and JA 0705. And specifically on page JA 0705, paragraphs 4 and 5 of what I was referring to as the Quantum Insider article. It states, companies must strike a fine balance between explaining the investment thesis and painting the future potential of businesses without straying into hype and misinformation. That is exactly what we allege IonQ was doing, and which we support with testimony from an insider who was there, who confronted the CEO of the company about his misrepresentations, and who identifies people who spoke to the Scorpion report. I do understand and grant Your Honors.
But they're all anonymous, are they not?
We know the identities.
Well, we don't know the identities, and neither does the market.
Yes, but the market can evaluate whether what these individuals are saying may check out. And certainly, and I don't want to get sidetracked, Your Honors, off the point of loss
Well,
causation, unless you would like me to leave
You're
that.
over your time now. Do you want to cover that on rebuttal?
I will cover that on rebuttal. Thank you very much, Your Honors.
All right. Mr. Blair?
Good morning, Your Honors. May it please the Court. My name is Ryan Blair from Cooley LLP, and I am here on behalf of the IonQ defendants. I'll note that IonQ's General Counsel, Stacy Giamalis, is here with us this morning. Permeating plaintiff's case is a global deficiency that is fatal to Plaintiffs' Exchange Act claims. Plaintiff's case rests entirely on unreliable and uncorroborated anonymous sources contained within a financially motivated short seller report that expressly disclaims its own accuracy. That is where I would like to first focus my argument, followed by a discussion of why plaintiff's sole confidential witness, CW1, also is unreliable under this circuit standards. And then I will lastly address why plaintiff's two
But
alleged...
why is it that, all of that sounds like we're at the summary judgment stage. This is at the pleading, the motion to dismiss stage. Why aren't the paragraphs that opposing counsel cite to us from the complaint sufficient at this stage?
Sure, Your Honor. So with respect to loss causation, the Hunter case makes clear that plaintiffs must satisfy Rule 9b's particularity requirement for pleading loss causation with sufficient specificity to evaluate whether the necessary causal link exists. This court's decision in Miller versus Asensio, which is 364 F3 233, further clarifies that it's a defendant's alleged misrepresentation, not just a negative company event like an earnings miss, that must be the substantial cause of the investor's loss. And here, due to the unreliability of the Scorpion report, which I will get into, and CW1, plaintiffs cannot establish that specificity, that any undisclosed truth leaked out in the report.
Because the reports are unliable and the sources are anonymous, so they can't meet the 9b burden.
That's correct. That's correct, Your Honor. But
What's the theory of loss in the complaint? I mean, if you have a short seller who puts out this market information with the idea that if the market goes down, they benefit, the normal situation is where a person purchases and loses profit that they otherwise would. But here, if their action becomes true, they make money instead of losing money.
that's correct.
And they say, he alleges, I don't know if the complaint does, he alleges they sold in this period, which means they made money. So what's their theory of loss?
So with respect to Scorpion Capital, they didn't lose. They lined their pockets by issuing what, frankly, Your Honor, is a hit piece on the company. And part of the reason why the Scorpion report doesn't establish loss causation is because while this case is on all fours with Nectar, B of I, and Berkeley Lights, which, by the way, involved another Scorpion report that had the same exact express disavowal of any accuracy whatsoever. And importantly, with the Scorpion reports, they even claim that they ignored and omitted positive information about the company that was provided by these anonymous sources, who, as you know, we don't know. But the Scorpion
Is Nectar, is that the Ninth Circuit case?
That is the
Yeah,
Ninth
okay.
Circuit Court. That's correct, Your Honor. But our case is even stronger than the Nectar cases and Berkeley Lights, because the Scorpion report just doesn't take shots at IonQ, but it bemoans the quantum computing industry as a whole. Put differently, even assuming the dubious assumption that investors reacted negatively on account of the report's issuance, given its character, it's unclear whether they did so due to statements specifically relating to IonQ and its technology, or to statements questioning the viability of the quantum computing industry as a whole. I'll give you just two examples. At Joint Appendix 514 through 521, the report highlights certain scientists' opinions, emphasis on opinions, that quantum computing as a whole will never be commercialized. And at Joint Appendix 588 through 615, the report talks about the small number of qubits for all current quantum computers and the lack of suitable error correction generally within the industry. Of course, these are the precise risks about which IonQ warned investors, that it may never achieve broad quantum advantage with its 32-qubit computer or any others, that at least 72 algorithmic qubits, which was the benchmark to determine how powerful a quantum computer was needed to actually challenge classical computers, and that significant advancements in error correction to make the machines more reliable were needed in order for them to make these steps. Thus, some of these disclosures in the report can only amount to the materialization of a known risk, which investors already knew, which can't establish loss causation. And secondly, with respect to the articles that my friend referenced during his argument, I want to be clear that none of them addressing the report gave the report any credence. The first three of the articles merely framed it as what Scorpion alleged, not what they analyzed and determined to be true or false. And the Quantum Insider article viewed the report strongly with skepticism and cast doubt on both its accuracy and import, precisely for the reason he stated. Quantum computers aren't designed to add 1 plus 1 and 1 plus 2. And so to put that in a report really shows what IonQ described the report quite full-throatedly as breathtaking in its ignorance of the quantum computing industry as a whole. But separate and apart from sort of analyst reaction to the Scorpion report was certain customers who were identified specifically in the report. And this is at JA 718 and 720. Two customers that were cited in the report publicly renounced it as inaccurate and not reflective of their relationship with IonQ. Next, I want to talk just briefly about the press releases that my friend talked about in response to the Scorpion report, IonQ's reactions. Now, it's probably unsurprising that plaintiffs never allege what IonQ actually said in those press releases. And so I want to put that in the record. The first release was on May 4th at JA 690, and it states, quote, "Yesterday, a report was issued by Scorpion Capital containing important inaccuracies and mischaracterizations regarding IonQ's business and progress to date." IonQ went on, and this is at JA 692 to 693. Quote, "Last week, the group Scorpion Capital published a poorly researched report that is riddled with disinformation, demonstrating a breathtaking ignorance of the quantum computing industry in general and IonQ technology in particular." Now, in what world would either of these releases, quote, "reveal to investors that the report's claims were likely true"? That's what plaintiffs claim in their reply brief at page 9. In all honesty, that's nonsense. And I asked the panel to look at the Joy case. This is 2021 Westlaw 653-6670 at star 9, where the plaintiffs alleged this sort of exact argument, and the court soundly rejected it because the issuer in that case stated that the report contained numerous errors, unsubstantiated statements, and misleading conclusions and interpretations. That's all IonQ did here. Now, plaintiffs make much of that we didn't go line by line addressing each of the claims that the Scorpion report made. Frankly, IonQ has more important things to do, like develop its quantum computers, which is exactly what it was doing. But because the report went after the quantum computing industry as a whole, it did believe it needed to make these statements to say that the quantum computing industry is developing, it is young, but it is ongoing. Your Honor, real quick, as to the Scorpion report and why it's unreliable, plaintiffs in their papers have suggested that we're somehow trying to raise the standard. We certainly are not. We have never argued that the Scorpion report is unreliable simply because it was authored by a short seller. Instead, at all times, we've argued here that allegations drawn from short seller reports must be viewed with caution because short sellers have an obvious motive to exaggerate any potential shortcomings of the targets of their short positions, especially where the exclusive source of those allegations come from anonymous sources. And we've cited a number of cases in our papers, the Meow case, Joy, and Berkeley Lights, as guidance here because the Fourth Circuit hasn't addressed this specific issue, confidential witnesses that were asserted in a short seller report. And the Meow case provides an exhaustive discussion of the, as they say it, twinned concerns of anonymous sources cited in a financially motivated short seller report. And at Meow at 442 F sup 3D at 803, 804, they list 5 potential indicia of unreliability under such circumstances, and every single one of them is present here. So I'll go through the 5 very briefly. First, all of Scorpion's anonymous source allegations are unmoored in time. These discussions, there's no representation as to when they occurred, and in fact, the Scorpion report's disclaimer freely acknowledges that the information provided by these sources, quote, may be outdated. Second, the alleged former employee sources are described only as, quote, former IonQ executives or employees, without regard to what their duties were, in which division they worked, or when, or whether they even worked on ARIA, which is the machine that plaintiffs claim don't exist. Now, those details are the critical ones necessary for this court's determination under the Hunter case, which sets out the circuit standard for confidential witness allegations. And again, the same goes for the report's purported experts whose credentials aren't provided, which makes their Scorpion's purported experts adding 1 + 1 or 1 + 2 on IonQ's Harmony machine, which is an 11-qubit machine, all the more sort of nonsense, particularly when plaintiffs do not, because they cannot, offer any information about the soundness or quality of the technical analysis in the report. Excuse me. The third point, Your Honors, no independent, well-pled factual allegations corroborate the Scorpion report's claim that ARIA didn't exist. And in fact, the record plainly demonstrates, this is at Joint Appendix 457 through 491, that ARIA was in use during the class period. And peer-reviewed research articles, including known entities like Fidelity, Goldman Sachs, and a quantum computing industry-driven consortium called the QEDC, bear this out. Again, that's at Joint Appendix 457 through 491. Put simply, to give credence to plaintiff's theory that ARIA didn't exist is to believe that each of these renowned third parties were somehow in on this fraud. That simply doesn't pass the smell test, Your Honor. The fourth point, plaintiff's counsel is not alleged to have done anything whatsoever to confirm the identities or statements of the anonymous sources cited in the Scorpion report. And as the Meow case described, such allegations, where neither investigated nor corroborated, sit at best uneasily with the requirements of Rule 11. And the fifth point, finally, the Scorpion report is riddled with clear factual errors. Most notably, both Scorpion and plaintiffs conflate the distinct concepts of accuracy versus error rates in the quantum computing context, a distinction that is clearly described at Joint Appendix 416. Now, plaintiffs make no attempt to explain why this panel should credit the report's assertion that the two are the same. And again, as Meow noted, plaintiffs' failure to recognize and engage with the dubious reliability of the Scorpion report is really concerning and necessarily raises doubt as to whether the other factual representations in the same report can be credited as a reliable basis to establish the factual falsity of IonQ's public statements. And Your Honor, with my last minute, I'd just like to highlight something that was raised in the Macrogenics case. And the court in that case recognized that cutting-edge technology companies like IonQ constantly find themselves in the hot seat because they must walk the line between expressing enthusiasm for the incremental advances they make and setting realistic expectations for investors in a potentially transformative industry. Here, IonQ carefully walked that line and forthrightly disclosed to investors both the advancements and limitations of its quantum computers at all times. The district court's decisions should be affirmed. Thank you, Your Honors, unless you have any questions.
Thank you. Mr. Hines?
Good morning, Your Honors. May it please the court, Michael Hines on behalf of the DMY defendants. I plan on using my very limited time to discuss the lack of particularized facts giving rise to a strong inference of scienter or fraudulent intent. As in this circuit, to plead scienter, a plaintiff must allege particularized.
Well, if we find there's an inadequate pleading of loss causation, we don't need to address that, do we?
You are 100% correct. You do not. When plaintiff's allegations are analyzed under the standards articulated time and again by this court, we respectfully submit that the complaint does not allege any inference of scienter, let alone the cogent and compelling inference of fraudulent intent required by the PSLRA. And plaintiff's scienter allegations generally fall into four categories. The first one is that DMY defendants conducted generalized due diligence, so therefore must have known of problems. Secondly, that all the defendants were motivated to sell stock in the future. Third, Mr. DeMasi in particular has a master's degree in physics. And lastly, the challenge statements discussed IonQ's so-called core business operations. And this court has rejected each and every one of those individually or collectively time and again. Turning first to due diligence, plaintiffs allege that the DMY defendants conducted due diligence on IonQ over 16 weeks prior to the merger. And according to the plaintiffs, that due diligence was comprised of meetings and calls with IonQ's management team and also receiving access to a data room that had certain financial forecasts and a management presentation about IonQ's technology. But nowhere in the complaint are there any allegations at all about what the DMY defendants learned during those alleged meetings and calls with IonQ's management. There are also no allegations whatsoever about what was learned through the referenced IonQ management presentation concerning IonQ's technology. And those lack of allegations are fatal. And this court rejected identical allegations in the Sionis Health case, holding that the fact that mere general due diligence occurred does not support the inference that defendants learned anything specific. That is also true here. Regarding motive, this court has held many, many times that alleged motives that are common to every executive in corporate America, such as a desire to increase one's own compensation through stock sales, adds very little to an inference of fraud. And contrary to plaintiffs' arguments, that's also true in the context of a merger transaction. In the Phillips case, this court addressed that very thing and held that allowing plaintiffs to allege motive based on a merger and realized gains on company stock would force every director of every company in corporate America to defend security fraud actions every time that a company affected a merger. Same is true here. And last but not least, also inadequate as a matter of law are plaintiff's allegations about Mr. DeMassi's education and experience, and that the individual defendants must have known of problems because their statements addressed the so-called core operations of IonQ. Those allegations are nothing more than impermissible allegations that executives acted with Scienter merely because of their status. And this court in Yates rejected the same kind of allegation, holding that we require additional detailed allegations establishing a defendant's actual exposure to any problems or issues. No such allegations are present in this case. In short, all of plaintiff Scienter allegations are directly contrary to the standards set forth in Yates, Sionis Health, Phillips, McGuire, Cosarelli, and many of the other cases from this court. We respectfully submit that the dismissal should be affirmed. Thank you very much.
All right, thank you. Mr. Calandra?
Thank you, Your Honors. I do want to focus on what Mr. Blair said about defendants' response to the Scorpion Report. The Scorpion Report, remember, the chief disclosure that we have confirmed with CW1, who confronted Defendant Chapman personally multiple times about the fact that he was not being honest about the existence of a 32-qubit computer. The chief disclosure in the Scorpion Report was, does a 32-qubit computer exist? And Scorpion said, we have talked to numerous insiders, and they say no. In defendant's response, all they had to do was say, we have a 32-qubit computer. It's right here. And they didn't do that. And I submit that that is exactly why on May 5th, the stock price plummeted. There was no other news about IonQ out there. And we aren't asking or suggesting that defendants needed to go line by line through the report and refute each claim. What we're suggesting is that they should have said, we have a 32-qubit computer. And they didn't. And I'm thankful that Mr. Blair brought your attention to sections or pages, Joint Appendix 457 to 491, because if you look at them, you will find that none of them involve a 32-qubit computer. The JA 458 to 64, an 8-qubit computer. JA 480 to 85, a 21-qubit computer. And then JA 487 to 91, that is from January 2023. That is after the class period. That still only refers to 21 qubits. They don't have this computer. And the entire point of this company was that we have the computer. And so investors, going strictly to loss causation, as Judge Agee, you seem to suggest that that is the fulcrum, and we agree, where this court can affirm or reverse. The Scorpion Report revealed, and this is pursuant to the test in Singer, that the 32-qubit computer did not exist. And we have multiple sources that confirm that it did not exist. And the idea that Mr. Blair said we did not try to confirm the identities, we've confirmed 2 identities. So that is false. And when the Scorpion Report revealed the previously undisclosed facts that this computer did not exist and the stock price fell, that, at face value, fulfills the test in Singer. And we go beyond that in showing that journalists covering this associated the decline in the stock with the disclosures in the report. And one of the cases defendants cite, Bajuri, a case from the District of Arizona that says journalist articles aren't important. The important distinguishing factor is that in that case, there were other causes the court was attributing to the decline of the stock, and the stock price fully rallied. Here, the stock price didn't rally, and there's nothing else happening about this company other than the disclosure of the Scorpion Report. And that takes us again to defendants' election on their own. They weren't obligated to say anything to the markets about the Scorpion Report, but because investors were crediting it, because investors were trading on it, they affirmatively went out and made a mealy-mouthed, non-denial denial about how, without identifying any specific flaw in the report, that it was riddled with misinformation.
Mr., let me ask you about CV1. He referred to the fact that there was a computer the size of a SUV. Was he referring to the 32-qubit?
He was referring to the latest version of their computer, which did not have 32.
I thought he was talking all the way through about the 32 computer. At one point, he says he heard it did not exist, and then he says it did exist, but it was the size of an SUV.
That is how defendants have framed our allegations.
That's what I'm asking you.
And that is not what we allege. What we allege is that the 32-qubit computer did not exist, and we have cited conversations in time with Chapman, who did not respond. Chapman is the CEO, did not respond, that's not true, but just kind of wandered off, even when CW1 threatened to quit. And then separately.
He was in sales, right?
In sales, but was required to sell the very technology that the company was developing, and who worked with the physicists who said that it could not be miniaturized and that it didn't exist. The very physicists working on this told her that it did not exist within a week, within a week of him joining the company.
Okay, thank you. I think your time is up.
Thank you, Your Honors.
We'll come down and greet counsel and then proceed on to the next case.
All rise.
All right, the next case we'll hear this morning, the United States versus Mosby, and Mr. Volchuk, whenever you're ready, we'll hear from you.
May it please the court, Daniel Volchok for Marilyn Mosby. Your Honors, I'd like to start with our challenge to the jury instruction on venue at the mortgage fraud trial. The Supreme Court has repeatedly emphasized the importance of the venue right, one of only two rights so important that the framers put it in the Bill of Rights, even though it was already in the original Constitution. And this court, to safeguard that right, has made clear that venue is proper only in a district in which an essential conduct element of the charged offense occurred. The instruction here was erroneous under that holding because it allowed jurors to find venue if, quote, any act in furtherance of the charged offense, unquote, occurred there. That phrase, any act in furtherance, is broader than essential conduct element. It includes preparatory acts.
Well, it may. It seems to me, if you read it in context, the crime is defined, in furtherance of the crime is defined in the instructions relating to the four elements the court instructed. And the charge that the court gave was actually a question of whether it fairly stated the law. It apparently is the charge that district courts give. It's in the model instructions, and several circuits have given that same instruction. So the question is whether there was an act in furtherance of an element of the crime. The crime was defined. The instruction didn't use the word elements, but it did refer to the crime charged.
So, Your Honor, we know from this court's decision in Rias that for this offense, this charge, Venue is proper only where the alleged false statement, so here the gift letter, only where the alleged false statement was submitted or received, essentially where it was communicated. And there's no dispute that it was received outside of Maryland, so for venue to be proper here.
Well, I don't know if you're going to the sufficiency
No,
of the
I want to
evidence.
stay on
Yeah, because the sufficiency of the evidence goes to where Ms. Mosby was when she sent it. And the government argues that the circumstantial evidence shows that she was still in Maryland.
Correct, and I want to stay on the instructional area, Your Honor. And Sterling held that a materially identical instruction, the government doesn't dispute that the two instructions were materially identical. Sterling concluded that that instruction, quote, erroneously allowed the jury to find venue based on a finding that any preparatory act occurred in the Eastern District of Virginia, end quote. That's page 245 of Sterling. Now, the government has.
Let me ask you this, counsel. As Judge Niemeyer indicated, this is a model instruction. Is your argument that the model instruction per se is invalid, or is it only invalid with respect to the mortgage fraud venue question?
So it is certainly not per se invalid, Judge Agee. As I think your question was getting at, different crimes can have different proper venues. It depends, of course, how Congress defines the crime within the constraints of the constitutional venue right. So it is certainly not the case, and both Rias got into this and Sterling got into this in a footnote, that sometimes saying act in furtherance, Rias talked particularly about conspiracy. Of course, conspiracy includes an overt act in furtherance of the conspiracy. So there are certainly cases in which it is appropriate to talk about an act in furtherance. But I want to get to the point about the government's arguments regarding Sterling. First, it says it has two arguments. So first, it says that the part of Sterling we're relying on is dictum. I submit that's wrong for the reasons articulated in our reply brief, but it wouldn't matter even if it were right.
Well, there were
Because-
other instructions in Sterling that sort of saved the day there for the government.
Absolutely, Judge Agee. There is no such instruction here. This gets to harmless error, which I do want to get to, but I have to persuade the court first that there was error. But there was no corrective instruction here, and I'll talk about it briefly. One of the instructions this court noted, the curative instructions in Sterling, the district court told jurors the defendant was entitled to be tried in the district where the offense was committed. There was not only no such instruction here, there was the opposite. Look at JA 2439, which is the jury instruction on venue. The court told the jurors that the government did not have to prove that the offense was committed in this district. I mean, that is directly contrary to the text of the Sixth Amendment and Article 3. So it shows the error and the lack of harmless error. But if I can conclude on Sterling and why we know that Sterling should be followed even if this court is not bound to, the government says that act in furtherance excludes preparatory acts, that it is substantively equivalent to essential conduct element. I submit just as a facial matter, as a matter of plain English, the notion that those two phrases are equivalent is wrong. Again, we know from Rias that the only place the essential conduct elements for this charge are where the offense was submitted. But preparatory acts, so we're talking about the gift letter, where the gift letter was submitted, but preparatory acts could include, for example, signing the gift letter, drafting the gift letter. And perhaps the best evidence refuting the government's equivalence argument is prosecutors' own closing argument to the jury. Pretty much their entire closing argument on venue was that they had proved an act in furtherance, and that's a phrase they used, as I'll illustrate in a moment. They said they had proved an act in furtherance in Maryland because they had shown preparatory acts there. So specifically, they said to the jury that we, quote, showed you that the mortgage applications were prepared in Baltimore. That's JA 2326. Their entire venue argument was about a minute in length.
So if we were to agree with you on this point, what would the result be?
A reversal of the mortgage fraud conviction, and of course the forfeiture order would go with that. The government hasn't disputed that part of it, and the government would have the option to retry.
On that charge?
On the mortgage fraud charge, correct. The jury acquitted on the mortgage fraud count as to 6 of the 7 alleged false statements. If this court were to reverse because of instructional error, it would be permitted to retry. But if I can just finish what the government said to the jury a few seconds after what I quoted a moment ago, still on JA 2326, they said the defendant's credit card transactions that took place at the time that she was preparing all of those loan documents, they were in Baltimore, end quote. And then a few seconds later, wrapping up JA 2327, top of that page, they said the defendant was in Baltimore when she took all these acts in furtherance, end quote, JA 2327. So even putting aside what I submit as the facial implausibility as a matter of plain English that act in furtherance and essential conduct element are the same, the government should not be heard to argue that the jurors here must have understood that act in furtherance excluded preparatory acts, because they argued just the opposite. Very quickly on harmless error, we talked about it a moment ago. Government has not shown beyond a reasonable doubt that the instructional error here was harmless. For example, as we said in our opening brief, jurors could have found that Ms. Mosby submitted the gift letter after she flew to Florida for the closing. The government didn't answer that argument in its brief. You don't need to go any further than that in order to conclude that the error was not harmless. I also talked about their closing argument a moment ago. I don't know how the court could conclude beyond a reasonable doubt, in light of that closing argument, that jurors would have found venue, again, beyond a reasonable doubt, based on the submission of the gift letter. The government didn't argue at all in closing about venue based on submission of the gift letter. So the error was, it was an erroneous instruction, and it was harmful. If I could turn to the perjury trial, the district court reversibly erred by admitting evidence of how Ms. Mosby used the money that she withdrew from her retirement account. That evidence was inadmissible because it was irrelevant, and alternatively, if it was relevant, its probative value was substantially outweighed by the risks of jury confusion and unfair prejudice. So starting with relevance.
It seems to me if the allegation is she withdrew it improperly with a mens rea of violating the law and lying, to show how she used the money it certainly goes to support of that intent. I mean, it's part of the story. I took the money out to buy a Ferrari or something like that.
So two responses, Judge Niemeyer. This court does not have before it a proper argument that the evidence was admissible because it was relevant to motive. The government did not argue that in opposing our motion in limine below, and they presented it to this court only in a footnote. We've cited the precedent from this court that says that does not properly present an argument.
It's part of the whole story, isn't it? I mean, you take out the money, allegation, you fraudulently take out money, and then you cut off the government and say, what for? Or was it actually spent, or was it, it's part of the story, in order to, and that's the last part of the sentence. I think that's
No,
a
Your Honor,
pretty
because
dicey argument to make.
why you took the money out was not part of the element, was not a part of this offense. It was simply
It's part of the story,
That's-
to prove the offense, all
That's-
the aspects, and it makes it more credible that it was fraudulent if it's an extravagant or unnecessary expense or large expense or whatever.
Judge Niemeyer, this court regularly and quite properly affirms convictions when an appellant does not properly preserve or present to this court even the most persuasive argument, and I submit it should do the same here with the government's forfeited motive argument. But even if the government disagrees, if the court disagrees, I'm sure the government disagrees, if the court disagrees and thinks that the evidence is relevant, it still should have been excluded because its probative value was outweighed by the risks I mentioned a moment ago. And let me start with confusion of the issues. The district court never substantively addressed our confusion of the issues argument, and we've cited the precedent in our opening brief that alone is an abuse of discretion. The government did not dispute that point in its brief, so the court doesn't need to go any further than that to find error. But if the court wants to go further and consider the government's argument, all that the government says is that the jurors are presumed to follow their instructions. But as we explained in both of our briefs, the jury was not instructed that there were no limits under the CARE Acts as to how a person could use the money that they withdrew. So our confusion of the issues argument is unrebutted by both the district court and the government. And of course, that's enough. You don't need to go further than that. But there's also the risk of unfair prejudice. Our briefs explain how the government used the use evidence throughout trial to try to secure convictions by fomenting wealth-based prejudice against Ms. Mosby, putting aside that she was not wealthy even before these prosecutions devastated her financially. And the government's argument in its brief is that we can't point to the closing argument in making this point because we don't challenge the closing argument as a standalone reversible error. Well, putting aside that the closing argument is not remotely the only place at trial that these appeals to wealth-based prejudice were made, the government doesn't offer any authority or any logic for the notion that we have to make one argument in order to make the other. Whether the closing argument is a standalone reversible error and whether it helps show the undue prejudice and hence the inadmissibility under 403 of the use evidence are two different arguments. Again, no logic
Before
or
you
authority.
sit down, could you talk about the forfeiture issue?
Absolutely, Your Honors. We have two arguments. Let me focus, if I could, in my time on the excessiveness argument. even if the government had proved that the forfeiture here was statutorily authorized, we submit it hasn't, but it would still be unconstitutionally excessive. The amount of the forfeiture is excessively large at $750,000. That amount is about 150 times the value of the gift letter, which is the only basis for the forfeiture.
They usually measure, the Supreme Court usually measures excessiveness by looking at the maximum fine that could be imposed. What is the maximum fine in this case?
$1 million, Your Honor, and that is the government's principal response here as to
Well,
the...
they've said it, and we've said it. That's one of the factors that we look at under excessive forfeiture under the Eighth Amendment.
This court is obviously bound by Supreme Court precedent, Supreme Court holdings, and holdings of this court. I do not understand how it could be the case that Congress could, I mean, we're making a constitutional argument. I don't understand how you say Congress can wipe away the protections that the founders put in the Constitution against excessive fines by passing a
The
statute.
analysis goes a little deeper than that. The analysis is the forfeiture has to be related in some sense to the gravity of the offense. And the gravity of the offense is measured by the penalty that can be imposed. And so the Supreme Court says if you can impose a penalty of $1 million and you forfeit something that's worth $10,000, it's not excessive. That type of analysis. So it goes to the fundamentals of what is excessive, and they usually use that measurement, and I think we have too.
So Judge Niemeyer, my time has expired.
Yeah,
May
why
I-
don't you answer that question?
May I
Sure.
respond briefly? So as we explained in our brief, courts have insisted on an individualized assessment precisely because, sure, the maximum fine that could be imposed is one way that Congress communicates how serious this offense could potentially be. Obviously not every offense for which, you know, the maximum fine could be imposed. That is why courts have said you must look at the particular circumstances. I already discussed why I think the circumstances here don't permit it. The one additional circumstance is that the alleged false statement here did not harm anyone. With that, unless the court has further questions, I'll save time for rebuttal.
Thank you. Mr. Bornstein?
Good morning, Judge Niemeyer, and may it please the court, David Bornstein on behalf of the United States. In 2020, Marilyn Mosby was one of the highest paid officials in the state of Maryland. She was also one of only 3 people in her office of more than 400 to take an early distribution from her retirement account under the CARES Act. In doing so, she committed perjury twice. She used the funds in order to make down payments on 2 Florida properties. And to make matters worse, to secure a mortgage on one of those properties, she then committed mortgage fraud. 2 juries in severed trials heard the evidence against her, both convicted. Now Ms. Mosby argues that her judgment of conviction is infected by
They
numerous
mostly
errors.
acquitted. There were some convictions, but there were a lot of acquittals too.
When it came to the mortgage trial, there were 7 false statements and she was convicted of 1. That is true, Judge Thacker. But I'd like to now, we have a lot of issues on the table. Unless any member of the panel would like me to begin elsewhere, I'll start where my friend did with the venue instruction. As Judge Niemeyer noted, this venue instruction is a model instruction. It's set forth verbatim from, it's taken verbatim from Judge Sand's treatise, Modern Federal Jury Instructions. It's a pattern jury instruction used by courts across the nation, including the 3rd and the 9th Circuits. It is fully consistent with Supreme Court case law, which has said that venue is proper in any district in which any part of a crime can be proven to have been done. That was said in Smith, citing...
Well, we have
Yes, Your
this older case, Reese, that says with respect to mortgage fraud, that preparatory acts, I'm kind of abbreviating now, preparatory acts are not sufficient to prove venue. And in that case, you know, of course, this is before email and all that sort of stuff. The actual mortgage fraud document was physically delivered in Pennsylvania, whereas the individual was charged in West Virginia.
Yes, Your Honor.
So even though that's a pretty old case, it's been cited with approval in Sterling and some others. And what is something of a question for me here is when I look at the jury instruction, which says in 2 places, whether in any act of in furtherance of the crime occurred, that would seem to permit the jury to conclude that a preparatory act alone, she drafted the letter, but didn't deliver it, didn't send it, didn't email it, that they could find venue based on that act alone, which would seem to argue, at least for this mortgage fraud claim, that the model jury instruction was incorrect. So help me out here.
Sure, Your Honor. First of all, we believe Rios is something of a red herring here because not even my friend is applying it properly. As you noted, Rios stands for the proposition, and it construed one of 13 statutes. That's a predecessor statute to Section 1014. Section 1014 took 13 prior statutes Congress did, and in 1948 they consolidated them within 1014. Rios construed only one of the 13 statutes, and there it said, as Your Honor noted, that venue is only proper in a bank fraud case where the bank receives the false statement. Not even my friend is taking that pinched of a view on venue. He concedes that if Marilyn Mosby transmitted the gift letter from Maryland, venue is proper in Maryland. In fact, my friend has never argued that Michigan would be the only proper venue because Michigan is actually where the mortgage lender was located. So given that fact.
Right, but whether or not she transmitted the letter from Maryland
Yes, Your Honor.
would seem to go more to the sufficiency of the evidence
Yes.
question. Because the jury instruction is a threshold, and even though there may be evidence that would be sufficient to find that there was distribution, that's not the same question we look at with the jury instruction, which is the jury free to convict or find this particular element based on something that's insufficient?
I understand. And Your Honor, so the nub of my friend's argument is that the any act in furtherance of language allows for the jury to find venue based upon preparatory acts. We disagree with that. One thing I would like to note, my friend relies entirely upon dictum in Sterling to prove the point. He actually never argues that it's persuasive, even in his reply
How do you disagree
brief, he
with it
doesn't.
when you argued it in closing argument?
Sorry, Your Honor?
You said you disagreed that the jury instruction allows for preparatory acts to be considered. You argued that way in closing argument.
Well, here, I think the disagreement is whether or not preparing the false statement is preparatory. Under this court's case law, and I'm looking at Leaker in particular from 1981, this court has said when it comes to false statement claims, if the element is making a false statement, which it is under Section 1014, venue is proper wherever that false statement was prepared or drafted. That has long been the
I
court's case law.
thought that was a case that involved mailing. Am I not remembering it correctly?
No, that was one where I think the court said that there were three proper venues because there was the preparation in one district, there was the transmission to an intermediary in another district, and then there was the receipt by the final recipient in a third district.
And did it involve mailing? I think that was the question. You're saying distribution. Was the distribution mailing?
I do not recall at this
Right.
time, Your Honor.
The court
But-
defined the crime in this case to have four elements.
Yes, Your Honor.
And I don't know if anybody's challenged the four elements,
No, Your
but
Honor.
it
No,
seems
Your
to me that this case wouldn't be affected by the argument made because the first element is making a false statement relating to an application mortgage business. And the evidence shows circumstantially that she made that in Maryland.
Yes.
There's also an element that it was submitted to the mortgage lender. That's a distinct element. Therefore, that's a fourth element. So it seems to me there's no evidence in this case of any preparatory act. The only act that could be thought of as preparatory is signing the statement in Maryland or filling out the form in Maryland.
Yes, Your Honor.
Which is the government's argument that she did. And accordingly, the in furtherance of would be probably include that act. But that's on the very same page and the next page in connection with the venue. So I'm not sure that the Model Act runs afoul in this case. I think Judge Agee's questions are really do call for. It would be better, I would think, in furtherance of any element of the crime. if you added any element, it would be nicer, a lot nicer.
Understood, Your Honor. And what you're saying, Judge Niemeyer, really goes to our harmlessness argument, which goes to the sufficiency of the evidence of venue, where if you look at the evidence, there's actually no evidence that venue was improper in
Before
Maryland.
you get to that, could you,
Yes,
you
Your
talked about Rios. Could
Of
you
course.
talk about our more recent Sterling opinion?
Sure. So the problem with Sterling, as I was saying, Your Honor, is that the decision there was not only dictum, where it said that the in furtherance of language is ambiguous as to whether it allows a jury to find venue based upon preparatory acts, but it's also contrary to this court's earlier decision in 2005 in Ebersole. And there's actually a footnote in Sterling about that. In Ebersole, this court looked at the exact same model instruction, approved it, and it did so while recognizing that the venue analysis must
What
focus
was
on
the
essential
underlying-
conduct.
What was the underlying crime in that case? Was it mortgage fraud?
It was wire fraud, Your Honor. It was
See,
wire
that's
fraud.
the real distinguishing factor here. This is mortgage fraud.
I know, but the analysis didn't turn on that, Your Honor. The analysis didn't turn on the specific offense that was at issue there. It didn't say, looking at this language, it will be one way or another. This is a general instruction that's used across the board. And my friend's challenge, he's really trying to overturn the model instruction. It's not keyed in to Section 1014 itself. But I'd like to explain why the any in furtherance of language doesn't actually touch upon preparatory acts. And the easiest way to see this is looking at the conspiracy context. Every first-year law student knows there are two things to prove conspiracy: a conspiratorial agreement and an overt act in furtherance of that agreement. And it's always understood that the
Well, there are
overt act
different
must follow the
elements with
agreement.
conspiracy, and I think that conspiracy, aiding and abetting, and a lot of this instruction would appear to be fine. We just have this unique situation created by this Rios case that seems to question the model jury instruction only in the context of a mortgage fraud case.
So Judge Agee, I just want to point out that what I'm doing is I'm focusing on the language that my friend is contesting, any act in furtherance of. That language is also used in the conspiracy context, and that language has always been understood as meaning that the act must follow the agreement. This court said so in Edwards in 1999, where it said that if the evidence showed that a mailing occurred before the scheme to defraud began, that mailing could not have been in furtherance of the scheme to defraud. The same thing happens in the conspiracy context, and against all of that, I think my friend bears a very high burden to argue that whenever a person hears any act in furtherance of, it can target preparatory acts. That's simply, again, not true in the conspiracy context, and it would be a sea change in the law for this court to hold otherwise. But I'd like to move on to our harmlessness argument. Any instructional error here was
So
clearly...
I don't want to belabor this,
Yes,
but
Your Honor.
do you think that Rios is just wrong?
Yes. So we think Rios is wrong, and here's the clearest reason why. So Rios believed that when it came to the predecessor statute, which was bank fraud, or a false statement to a bank, it consisted of a single act in a single place, which was the receipt by the bank of the false statement. That was 1938, I think, was Rios. In 1980,
So
sorry,
you think it's, but it's, you agree it's precedent, but it's wrong? Is that what you're saying?
it construed a different statute, and then when the U.S. Supreme Court construed Section 1014, which Congress enacted a decade after Rios was published, the Supreme Court said that there are actually only two elements to Section 1014: the making of a false statement with the intent to influence a mortgage lender. There was no requirement of receipt by the mortgage lender, and that directly abrogates Rios, which said that the essential element was something that they read into the statute, which is
Rios
receipt
may
of the
not
false
be
statement.
incorrect. It seems to me this in furtherance of is focusing on an element. And so if we look at the elements of any one of these offenses, it makes them all consistent.
I agree, Your Honor. and
The Rios case required a receipt, whereas in this case, it's the making is one of the elements.
Yes, absolutely.
And the making is done by signing the form. And the Supreme Court made that clear also. It focused on the two elements.
Yes.
And so when you talk about venue and then you give the four elements here, it relates the two that in furtherance of one of the elements. And the element here is, it says, first, that the defendant make a false statement or report relating to an application to a mortgage lending business. That's the first element. And so you have to make it, and the only way you make it is in writing by signing that document.
Yes, absolutely, Your Honor. And I'd also like to simply note, to be fair to my friend, RIAS involves the same language, except that the Fourth Circuit in 1938 imported atextually a separate element, which is receipt by the lender, and said that's the only element that matters. By 1982, the Supreme Court says we look at the text of the statute, and there isn't that element in it, and that's why I think RIAS is abrogated. One final point, Your Honor. If you look at the district court's decision when it used the model jury instruction, when it adopted it, that's at Joint Appendix page 2261 and 2262, the district court specifically said that it found that the any act in furtherance of language meant any act within the contours of the offense. And I find it truly stunning that my friend will get up here, and this is what his argument hinges on, and he's never actually articulated, except maybe at
The
oral
district
argument for the
court
first
told the
time,
jury
why
that?
that's wrong.
The district court told the jury that?
No, Your Honor, because she
So
thought
what did
it would...
the jury only heard what's here in the record, right?
But the district court was talking about what she believed the plain language meant.
Well, I
And that
don't
is
know
my-
why that is relevant to what the district court actually instructed the jury.
It's relevant because, as I pointed out in the conspiracy context, this court, courts around the nation, juries around the nation, when they hear any act in furtherance of, it's accepted that people understand that the act in furtherance of must follow the beginning of the crime. I would like to move on to the
Well, the
harmlessness
district court
argument.
just quoted the form instruction, model instruction.
Yes, it was
It didn't
taken
go any
verbatim.
further.
Yes. I'd like to move on to our harmlessness argument. Now, my friend stood here and said, well, you know, the government says that everything that every gift letter-related act must have taken place between two dates. He says, however, they argue that it could have taken place on February 16th. We know that's false. The underlying facts are actually undisputed. Marilyn Mosby first learned that she needed to raise another $5,000 on February 2nd, 2021, when her broker, Gilbert Bennett, said she needed the money. On February 9th, 2021, he sent her the gift letter, and by February 10th, she had filled it out, signed it, and sent it to the mortgage lender, and we know that because that is when the gift letter first appears within her mortgage file, and that is when the mortgage lender cleared her application to close, and that was the entire purpose of it. There is no basis for my friend's speculation, which is that the jury could think that she submitted the letter on February 16th after her application was already cleared to close. All the evidence showed that the purpose of the letter was to get that application cleared to close. And I'd like to make this point perfectly clear, and this is why no matter what error one might think there is in the jury instruction, it was harmless beyond a reasonable doubt. It's harmless to whatever standard you want. There was simply no evidence showing that Maryland was an improper venue for this crime. Given that we know that everything Marilyn Mosby did with the gift letter took place on two dates, February 9th and February 10th, and other than my friend saying February 16th, that is otherwise just uncontested. It was a finding by the district court that was sent on February 10th. He doesn't argue that's clear error, so that is what we're dealing with. Marilyn Mosby lived in Baltimore. She worked in Baltimore. She was the elected state's attorney in Baltimore, and she spent virtually all of her time in Baltimore. We know this by looking at her bank record. She was a very active user of her check card or debit card. And it shows that for the 2 months preceding February 9th and February 10th, she didn't leave Baltimore once. She didn't have a single person purchase outside of Baltimore. Instead, she has a string of purchases within Baltimore. She had one a couple of days before she sent the gift letter to the mortgage lender. She had one several days after she sent it to the gift letter, to the mortgage lender. And as we noted, the Eighth Circuit in a case called Johnson, looking at absolutely the same facts, held that as a sufficient basis for the jury to find venue. But what is more, the evidence of venue here is stronger because the defendant in Johnson, between the 2 days earlier making a bank transaction in Minnesota and 6 days later making one in Minnesota, the defendant had left Minnesota for South Dakota. And the court still held that was a sufficient basis to find venue. Here, there is no evidence that Marilyn Mosby left Maryland. None whatsoever. And I'm not trying to shift the burden. I'm simply trying to say if my friend wants to say that the jury had any basis to find that venue was improper outside of Maryland, you would have pointed to one thing by now, showing that Marilyn Mosby had left the state of Maryland in early February 2021. He has pointed to nothing. So as a result, the jury looking at the evidence, there was only one proper decision as to whether venue was appropriate in Maryland, and it was. I'd like to now quickly move to use evidence and forfeiture. As to use evidence, Judge Niemeyer, as you point out, clearly the reason why or how Ms. Mosby used the funds that she obtained by perjury was relevant. As you said, it completes the story. My friend says, well, the judge couldn't have relied on that because the government didn't argue it below. But I'm not here to uphold the government's arguments. It's to uphold Judge Grigsby's decision. And I think it's perfectly intuitive for Judge Grigsby to look at this. She simply said, of course it's relevant. And she's not bound by whatever reasons the party gives. The judge, and in fact, any trial judge knows this. Very often they will be faced with a request by a party, and without even asking the other party for the response, they'll make a decision. So you're absolutely right. Not only does it complete the story, not only does it show motive, but it was also deeply relevant to whether Ms. Mosby had suffered an adverse financial consequence. And by the way, you know, my friend said that allowing in this evidence allowed for some sort of wealth-based prejudice. I would ask the court to look at docket entry 296, pages 11 through 13. That's relevant because Judge Grigsby actually put guardrails on the evidence after it came in. The government couldn't say these were luxury properties. The government couldn't show any photos of the properties. The government couldn't provide any description of the properties. And the reason why is Judge Grigsby wanted to make sure that the kinds of prejudice my friend is talking about wouldn't happen. The error that he's claiming, this is a motion in limine, is simply the evidence coming in. Now, my friend says that he can try to point to what he claims are errors that occurred at trial to show that letting in the evidence was harmful, but I'm unaware of any case that says that a judge's motion in limine could have been incorrect based upon things that are done at trial months later where there was no objection. You know, the onus is actually on my friend to argue how that's possibly proper. And finally, for forfeiture. My friend did not argue the statutory claim. He simply argued the Eighth Amendment. And here I would ask the court to look at its decision in Gillerum. In Gillerum, the court said in a single defendant case, it is virtually impossible for a defendant to argue that having to forfeit the proceeds of her crime is grossly disproportionate under the Eighth Amendment. That's because the purpose of forfeiture is to make sure that crime doesn't pay.
How much was the offense conduct in that case? Here it was $5,000.
No, Your Honor. Here, the offense conduct was roughly $430,000.
Well,
That's
that she
because-
was convicted of. What was
Yes.
she convicted of?
So she was convicted of mortgage fraud. And mortgage fraud,
And what's the $5,000?
so the $5,000 was the amount of the gift letter. But
Right. Is that what she was convicted of?
yes, but when you look at what were the proceeds of that crime, the case law isn't to look at the $5,000. Imagine, you know, she was also charged with lying about her liabilities. So, you know, if there's no numeric value for the liability, she just
You
lied
said
by checking
charged
boxes.
with. Was she convicted of that in this case?
No, Your Honor, I'm simply making the point that when
You're talking about relevant conduct for the,
No, Your Honor. I'm simply trying to point out that when we are looking at what the proceeds were, you don't look at the amount of the gift letter. You look at the amount of the mortgage she obtained. And the amount of the mortgage she obtained is $430,000.
all right. So, and the fraudulent letter was $5,000.
The fraudulent
But
letter.
for that, she got the 400 and whatever amount you're saying.
Exactly.
Okay.
It's by using that she got the mortgage. And I'd like to point out one last thing. Judge Niemeyer, you had a decision 2 years ago, United States against Toby. It's 85 F 4th 190. And there you point out that if a defendant receives a fine that is within the statutory range and the guidelines range, if the defendant does not argue that the statute allows for, Eighth Amendment violations and that the guidelines are too high, that it leads to an Eighth Amendment violation, they cannot claim that something that falls within their guidelines, which is presumptively reasonable, is an Eighth Amendment violation. You said it didn't even get off the ground, and I think that applies here. There's a lot more to cover, but this is merely touched upon what my friend decided to spend his opening on. If the court has no
Okay.
further questions, we'd ask the court to affirm.
Thank you. All right,
Thank you.
Mr. Volchek?
Your Honor, Mr. Bornstein says we're trying to overturn the model instruction. We most certainly are not, as I think Judge Agee was getting at.
That was going to be my first question.
Well,
Are
I'm
you
happy
trying
to
to
go to it,
over?
Judge
Yeah.
Thacker. A model instruction is just that, a model instruction, and it is appropriate for some circumstances and not appropriate for others, and it happens every day in district courts around the country that they modify a model instruction based on the facts and circumstances of a particular case. Let's talk about what's actually trying to be overturned here. It's Riaz. He said that. He was asked, do you think Riaz is wrong? He said, yes, this court is bound by Riaz. His answer is, well, it was abrogated by Supreme Court in Williams. Our reply
But if
brief.
you focus at Riaz, Riaz assessed, in order to making determination of venue, assessed the elements. And the element required receipt, and receipt was out of state. And that's fair enough. But then the Supreme Court focused on two elements, and my suggestion, under this same type of language, and my suggestion is if we focus on the elements, this is a perfectly appropriate, unless there was strong evidence of other conduct taken in preparation, which was not. We have a lot of cases where instructions are requested in view of the evidence in a particular case. Otherwise, we go to the general instruction. And in this case, the elements were given on the very same page that he, or the very next page after he addressed the venue, and lays out the four elements. And one of the four elements was the signing of that application, which puts it in Maryland. There is no evidence about the fact that she sat at a table or she went into a particular, somebody called her here and that was important. There's no preparatory evidence about signing it. They said she signed that paper in Baltimore. And of course, then the other elements come involved. She has to also transmit it. But one of the elements, essential elements, took place in Maryland, and which is in furtherance of it. I don't think Riaz has to be read inconsistent.
Let me try to persuade you, Judge Niemeyer, and your honors. The court, Mr. Bornstein talked about Riaz being atextual and the language here being different from there. Fine, let me try to speak to it more directly if I'm understanding your question, Judge Niemeyer. The crime in Riaz was exactly the same conduct crime as here, and I'll spell it out. Knowingly making a materially false statement for the purpose of influencing a financial institution in connection with a loan or application. That's exactly what's in the first sentences of Riaz, and it's exactly what happened here. So it was not about receipt, Judge Niemeyer. What it said was
Well,
communicating.
If that's so, then what Riaz focused on was receipt.
I don't think, well, what Riaz focused on, Judge Niemeyer, was communicating the false statement, making the false statement. It used the word make.
No, it didn't say, it focused
absolutely-
on where it was received.
No, I respectfully have to disagree. They were received and made in the same, I mean, they were communicated and received in the same place. So Riaz didn't have to get into this distinction of submitted in one place and received in another, but it is exactly the same crime. Where was the false statement communicated? The instruction here allowed the jury to find venue not based on where the false statement was communicated.
Of course, that's not an element here. That is one element, but that's not one of the four. I mean, that's not all the four. The four, communication, state was submitted to the mortgage, that's the fourth element.
Submission, not signing, submission of the gift letter.
But the first element is the making of the statement. The second one is acted knowingly. That's the mens rea. The third one is that it was made for a purpose, and fourth one, that it was submitted.
As Mr. Bornstein explained, the crime here is making the false statement. And Riaz explained that you make the false statement for venue purposes when it is communicated and in that case also received.
Well, what do you take to be do you think the court misinstructed the jury on these four elements? I didn't see you objecting to it.
No, we are not challenging the elements. We are challenging
Well, it seems to me it's clear that venue, under any case law or any interpretation, venue can take place where any element is committed of the offense, right?
Not under Riaz. I mean, Riaz says that where venue is proper for this
So you're
offense-
saying that the law that allows venue to be lodged where any one element of the offense is committed, you say that's wrong?
No, I am
That's
not
Supreme Court
challenging
law.
that. I am not challenging that. I am challenging the jury, the instruction allowed the jury to find venue where a preparatory act occurred directly contrary to both Riaz and Sterling. Now, on harmlessness, Judge Thacker, you asked him, how can you say preparatory acts and act in furtherance, don't include preparatory acts when you argued the opposite to the jury? He didn't answer, and I don't know the answer, but that shows both the error and why the error was harmful. Now, he said, The record is absolutely clear. It couldn't have been submitted by Ms. Mosby in person. He didn't cite anything in the record. He said it's clear that the gift letter was already in the mortgage file as of February 10th. Look at page 130 of the supplemental appendix. They put it in. This is a letter about what's in the mortgage file as of February 10th. It is dated. It is a list of enclosed documents. The gift letter is not there. There is nothing. We don't even know. There were so many gaps in the government's presentation here. We don't even know how the gift letter was submitted, by email, by U.S. mail, in person, by FedEx, something else. There is nothing to exclude that it was brought with her to Florida. He says Mr. Volchok hasn't pointed to anything about her ever leaving Maryland. It's undisputed. It is in the record. In the same credit card statements, they point to that she had a Spirit Airlines charge on February 16th, and then charges in Florida starting on February 16th. The closing was on February 19th.
Was the Spirit charge was made in Maryland, right?
No, I don't know the answer to that question, Judge, but I don't believe it was. But in any event, she clearly went to Florida on the 16th for the closing. I didn't even understand that prior to Mr. Bornstein's argument for that to have been disputed. There is nothing that would preclude a jury from finding that she submitted the letter then, and I don't know how this
No,
court...
I agree that there's my questioning you is your extension of your, not extension, but the principle that venue lies. I think we have a bunch of cases, and I haven't pulled them up because I wrote one several years ago, where any element of the offense is committed, venue will lie. Conduct committing any element, not preparatory, but an element of the offense. And so it's very relevant to look at the elements of offense in connection with deciding a venue question.
The elements of the offense here, and Mr. Bornstein said it, there are two elements. Making the false statement
There are
with the intent...
four elements, they were instructed.
But under the statute, it's making a false statement with the intent to influence a financial institution. And so it is the question under RIAS, which analyzed that same conduct, is where was the false statement communicated? As the government argued, the jury could have found here that it was...
Well, you're reducing it to one element, and that has to be your argument.
No, Mr. Bornstein said there are two elements. And under RIAS, which analyzes...
My point is this, simply, and we have a disagreement on this, I guess, but that when she signed that form, and let's assume she signed it at her desk in Maryland, at her house in Maryland, when she signed that form, she committed one element of the offense.
I do respectfully disagree, Judge Niemeyer, but even if we have that disagreement, I don't know how this court could conclude that this jury, presented with this evidence and these closing arguments that I've quoted to you, how this court could conclude beyond a reasonable doubt that it would have reached that finding. This is not my sufficiency argument. We've set that aside for the moment. This court, in order not to infringe her Sixth Amendment right to have this jury decide her guilt or innocence, including whether venue was proper, this court would have to conclude that these jurors, with this closing argument from the government that focused only on venue based on preparatory acts, nonetheless, beyond a reasonable doubt, would have found venue had they been properly instructed. I ask the court to set aside the convictions in the forfeiture order.
Thank you, Mr. Volchok. We'll come down. Do you want to break? Do you need okay. We're going to come down and greet counsel and then proceed on to the last case. All right, next case we'll hear today is Travelers Indemnity versus American Alternative Insurance Company, and Mr. Michael, we'll hear from you.
Good morning, Your Honor, and may it please the court. I am Mark Michael, along with my co-counsel, Mr. William Myers. We represent the Travelers Indemnity Company in this insurance coverage dispute. against American Alternative Insurance Corporation for the proper allocation between the two carriers of a $9 million settlement paid by Travelers to resolve two underlying state court actions. Those state court actions, very briefly, concerned 4 deaths in an apartment fire which occurred in Dobson in Surrey County, North Carolina. During the fire, the 4 victims were trapped in an apartment on the 2nd floor of the apartment complex, and they called and were in communication with Surrey County's 9/11 Operations Center, specifically Robert Cook and Joseph Shores. Without going into great detail, they were given bad advice. Shores and Cook, following a protocol set forth in the 9/11 Operations Manual, which only called with respect to residential fires for inquiries into the caller's name, the caller's number, where the fire was,
Well,
and
and
whether
this-
anyone else.
Counsel, in this case, as I understand it, may be incorrectly, that really the issue deals with 2 particular provisions of the insurance policy,
Correct.
right? So maybe the time would be better spent telling us why the district court was right or wrong in interpreting those provisions.
Correct. So the first issue raised by Travelers on the appeal then is whether the district court correctly determined or incorrectly ruled that the AAIC excess policy did not provide coverage. The language of the AAIC policy refers to fire, rescue, and incidental operations of Surrey County Emergency Services. So the question is, do incidental operations of Surrey County Emergency Services extend to the actions of the 9/11 operators on the night of the fire?
Maybe we could change the issue a little bit, because nobody seems to be challenging the fact that the underlying policy covered.
Correct.
So if the underlying policy covered, why doesn't the excess policy covered, which uses virtually the same language?
Well, that's our argument, Your Honor.
I know, but the argument is, the distinction is adding the words including, whereas the excess doesn't have the word including, but they both have of Surrey County Engineering Services.
That's correct, Your Honor. And the district court made a distinction between the primary and the excess policy based on very slight variations in the language of the AAIC endorsement, the named insured limitation endorsement. On the one hand, the primary policy refers to fire, rescue, and operations incidental thereto of Surrey County Emergency Services. The excess policy refers to fire, rescue, and incidental operations of SCES. And the district court distinguished between the two of those, held that the primary policy was ambiguous, the excess policy was not. With great respect to Judge Biggs, the error in her reasoning was in failing.
What was the distinction? The only word I see distinguishing the two is the underlying policy says including operations incidental there. It's other emergency services, including operations incidental thereto of Surrey
Correct.
County Emergency. The other one says emergency rescue or incidental operations of Survey County. So the word including just makes clear that it's included, and it seems to me that it's still incidental operations of the county. Underline is still incidental services of the county.
Correct. Correct, and that's our argument, right? Our argument is that the phrase of SCES is where the ambiguity lies. AAIC's position is very clear.
Well, if there's ambiguity in the lower one, there's ambiguity in the upper one, right?
Neither party contended in the district court or here that there is a distinction to be drawn between the primary and excess AAIC policies. Both parties have described the two provisions as being virtually identical and achieving the same effect. The distinction drawn by Judge Biggs was not one that was drawn by either party and is not one that either party defends here. We say that the ambiguity is found in the phrase of SCES because the AAIC representatives testified unequivocally that what that necessarily means and what it can only mean is incidental operations performed by members of SCES. Short answer is that's not what it says. It says incidental operations of SCES.
Well, it uses of, and that of could be going both ways. It could be of the department, or of somebody else related to the department.
Exactly,
But the lower court, the lower one could say that too, right?
correct.
The excess, when I say lower, I mean the underlying policy and the excess policy.
That's correct, Your Honor, and that's the basis of our argument that both policies are ambiguous and that coverage was extended
And
on
if
both.
you're right on that, then you get a total of $4.5 million.
Well, actually, it gets me to my next issue. We believe we get $6 million. The underlying settlement, as I mentioned, was $9 million. That was a global settlement paid to resolve the
And
cases
it was
against.
not allocated, was it?
It was not allocated in the prior action.
Well, I don't know how you guys can allocate it. Your argument supposes that we have to allocate it.
No, Your Honor. North Carolina law says that the $9 million is allocated $3 million to each defendant.
That's for equitable, for each defendant in a settlement?
No.
The $9 million was in settlement of the claims.
That's correct, Your Honor.
And it was divided among 3 parties, right?
Among 4 plaintiffs,
4 plaintiffs.
right.
And
Now,
one of them was the county.
no. The county was a defendant.
Excuse
below.
me, that's a defendant.
Yeah.
It goes.
Yes, sir.
Right, no, I understand.
There was a global settlement demand in the
Right.
underlying action.
$9 million, right.
In this action, North Carolina Contribution Act statute says that the allocation for contribution purposes is $3 million,
It's
$3 million,
divided,
$3
right,
million.
right.
Okay. Based on that, and because the traveler's policy preserved governmental immunity for Surrey County, whereas the AAIC policy does not, we maintain that the only policy to respond to that $3 million allocated to Surrey County in this action is that of AAIC.
Well, my point is, okay, let me ask you this question about immunity. Are there exceptions to immunity for gross negligence or malice?
There are, and there are exceptions
Well, that
for,
seems to me, would you be liable for gross negligence, your policy?
to the extent that Surrey County was held liable and was not held to be immune,
Right.
the traveler's policy would have responded.
Well, so you're arguing that somehow you're concluding that immunity would apply.
Yet, we are
Yet
arguing
you had the
that.
threat to cover it. I mean, there was a real legal threat, because the allegation of the complaint talked about gross negligence and malice.
Correct. And then what happens in this action, what we say is crucial to this action, is AAIC concedes that the traveler's analysis is correct. They say so in their brief, right? And when.
Well, that
when
goes
the-
to the volunteer thing, but I'm talking about the allocation. You're saying you should get a better allocation because your policy excludes liability of the county based on governmental immunity.
That's correct.
And I'm suggesting to you it doesn't necessarily exclude it, because you just agreed that if liability was based on gross negligence, then you would have to cover.
Or if immunity were not found at all.
Yeah.
We had an obligation to protect in the underlying action. We did not pay as a volunteer. In this action, when $3 million is allocated to Surrey County, and Traveler says that's not our responsibility, and AAIC agrees that the Traveler's analysis is correct, that necessarily means the only policy which responds to the $3 million allocated to the county is that of AAIC. So we contend, based upon the allocation established by North Carolina law and the concession by AAIC that that allocation is correct and the Traveler's analysis of the immunity argument is correct, AAIC has conceded that there's the only policy which would respond to this $3 million allocation.
All right, so coming out of the district court said, how much do you have to pay, and how much does the other party have to pay?
District court required AAIC to pay Travelers $1 million. The
You
district
got
court
the
said
other 8, and your client got the other 8 million.
Correct,
All right.
correct. My client has already paid the entire $9 million.
So
Which,
you either want 3.5 more, or you want 8 more.
I want 3.5 more or
or
5
5
more. Yes, that's correct, Your Honor.
Okay.
If there are no more questions on that, I'll move on to the argument raised by AAIC in their brief, which has to do with an alleged failure on the part of the district court to consider extrinsic evidence, which supposedly clearly demonstrates that the parties didn't intend for the call center to be insured under the AIC policy. The argument here is fairly simple, that it's been waived. Judge Biggs went to great pains in her opinion to say that the reason she didn't consider the argument is because AIC provided her
I
with no
thought there was an argument that under applicable state law, if there's an ambiguity, you construe the ambiguity against the insurance company.
Exactly.
But you don't necessarily go and change the insurance policy by extrinsic evidence.
That's exactly right. And the cases cited by AIC in this court, apparently there were none in the district court, in this court have nothing to do with the issue. I mean, AIC cites this court to cases involving discoverability of insurance reserves, an anti-nuptial agreement, a Maryland case, a lease case. None of them.
Maryland cases are not so bad.
The Maryland case is not a North Carolina case. And earlier cases from this decision, from this court, in which the court pointed to what I would contend is the crucial distinction, which is that extrinsic evidence is not admissible to vary or contradict the terms of an insurance policy. The simple fact of the matter is AAIC chose this language. This is an AAIC form. It's not an ISO form. AAIC could have written it to say incidental operations performed by SCES, and they would win.
Are both policies non-ISI forms?
Both endorsements are AAIC endorsements, Your Honor.
Anything else?
I'm sorry?
Anything else that?
No, Your Honor. So based on all that, we would contend the district court erred in not finding that the excess policy was triggered because the of SCES language is common to both policies and ambiguous. That AAIC bears sole responsibility for the $3 million allocated in this action, not in the underlying action, in this action to the county once AAIC has conceded that the traveler's analysis is correct, and that the failure of the district court to consider extrinsic evidence was entirely proper because AAIC has completely failed to present any case to this court that would allow the consideration of extrinsic evidence in North Carolina to vary or contradict a finding of coverage based on an ambiguous policy provision.
All right,
If there are no other questions, I'll reserve my remaining time. Thank you.
thank you. Mr. Kisloff?
Good morning, Your Honors. May it please the Court. Louis Kozloff on behalf of American Alternative Insurance Corporation. To first clarify one of your questions, Judge Niemeyer, AAIC absolutely does challenge that the primary portion of the AAIC policy provides coverage. Our position is that it does not, and the district court erred in that respect. Now, in most other respects, the district court's decision on the parties' cross motion for summary judgment was correct. Court correctly interpreted the named insured limitation endorsement of the AAIC AAC policy's excess coverage to say that it unambiguously provides limited coverage to SCES's emergency services operations and its incidental operations. Only those operations performed by SCES.
It doesn't say performed by, it says of.
Correct.
And the underlying policy uses the same preposition, of.
Correct. Both policies have nearly identical wording. Both policies state that what the policy covers are injury arising out of specific emergency services that SCES performs, ambulance, firefighting, there's a fire marshal that's part of SCES, and other emergency services.
And both of them include incidental operations.
Correct. Incidental operations of SCES.
Right.
Those
And-
of SCES. Of is possessive.
Right,
It
and the
means-
underlying policy is of too. So you're suggesting that, are you suggesting they should be interpreted differently? Or you're suggesting they both should be interpreted not to include third-party?
The latter. Both should be interpreted so
Okay,
that.
okay, I understand your argument, okay.
Okay, thank you, Your Honor. So in that respect, the district
You
court
would want to
erred.
reverse the district court with respect to the underlying policy.
The primary,
Yeah, right.
primary part of one, I should clarify, it is one policy, under one policy number, that has two coverage parts, a primary part and an excess part.
right.
And that is one of the key reasons why it was improper for the district court to interpret two parts of the same policy differently, and to apply a construction to the primary part that's different from the excess,
And
because,
that's your cross appeal, that you were told to pay $1 million.
correct, that is
Right.
the cross appeal.
And so if the phrase in both the underlying and the excess policy are interpreted the same, in your view, then you get $1 million back.
Correct, Your Honor.
Both of you seem to agree that the two policies should follow each other. It's just that you disagree on the meaning of the two provisions.
I think that's right,
Your
Your Honor.
interpretation, you get $1 million back. His interpretation, he gets some more subrogation money.
Correct, Your Honor.
Yeah,
We
okay.
think that is the core error in the district court's ruling. And the correct one was the one that Judge Biggs applied to the excess coverage part. And the reason why that's correct is not only is the wording clear, the language of SCES is possessive, as I said. So both the emergency services that are covered and the incidental operations that are covered are those of possessive SCES. It basically would be the same as if it said SCS apostrophe S's, emergency services and incidental operations. And also the reason why that interpretation is correct, it's a single policy, as I said, should be construed harmoniously and consistently, but the entire purpose of the county's insurance program is that it had a broad policy that it purchased from travelers that covered all of the county's operations, broad operations, anything the county did for its citizens. Whereas the AAIC policy is more limited. It's a supplemental policy that covers only the SCES. Now, they couldn't write that policy with SCES as the named insured. That would be an easy way to perhaps solve this conundrum that we're here today for. But just as in the underlying lawsuit by the victims of the fire, SCES was not a proper defendant in that case and was ultimately dismissed because it's not a separate legal entity that's capable of being sued. It's just a department within Surrey County. So for the same reason, the policy couldn't be issued to Surrey County Emergency Services. It had to be issued to the county. So how then does the policy demonstrate that the only thing that it covers, the limited coverage that the county purchased in that policy?
The linkage between the two is pretty close because the emergency services was dispatched, could only be dispatched, well, not could, but it was only dispatched by the 9/11 group.
Correct, Your Honor. Sorry.
And historically, those were part of the same operation. They're now separate operations. But it's very closely linked to the services of Surrey County Emergency Services because that's the way they got there. And so the question, even factually, you could ask is, even if you give your interpretation, whether incidental services of Surrey County Emergency Services includes the dispatching.
You're right, Your Honor. I'll make 2 points, or maybe 3, in response to that. First, the underlying claim involved no negligence by the SCES in any way. There's nothing that the first responders from the ambulance corps of SCES did that in any way caused the victim's death. That's acknowledged and admitted in this case. It was the negligence of the 911 operators in providing poor advice to the victims that caused their death. And it was also alleged that the county, in training the 911 operators, was negligent. So there's nothing that SCES, the insured entity, did that gave rise to this liability. And then you're right, the 911 operators did dispatch a host of personnel, including some from SCES, but that does not make the 911 operations incidental to SCES's operations. And the reason is incidental does not mean, and the district court said, what the 911 operators did was not just incidental, it was in fact necessary, it was vital, it was instrumental to their work. Well, instrumental, essential, vital, necessary are the opposite. They're antonyms for incidental. Incidental, as it's been interpreted in North Carolina case law, excuse me, I'm battling a cold, is very different from necessary or vital. Incidental means a fortuitous consequence, something that happens by chance, something that's a lesser consequence of the main thing being here SCES. So the fact that the court said, and Travelers in its briefing says, that the dispatch was vital or necessary demonstrates that it's not incidental. Therefore, we continue to maintain that the only reasonable interpretation of the named insured limitations endorsements in the policy is the one that limits coverage.
The primary policy has another word that we haven't discussed. It said operations incidental thereto. And thereto is referring, I suppose, to firefighting, ambulance, rescue, and other emergency services. And then it says incidental operations incidental thereto.
Correct.
That would seem to be broader than just operations performed by SCES.
You're right, Your Honor. And I've looked at these provisions extensively, as I'm sure all of you on the bench have. And I believe there's really no fundamental, meaningful, material difference between.
Well, let's not talk about the difference now. Let's just talk about incidental thereto. You were giving us definitions of incidental, and I was saying incidental thereto refers to the identified services of firefighting, ambulance, rescue, or other emergency services.
Correct.
And then it adds operations incidental thereto.
Correct.
Now,
So,
that more clearly goes beyond incidental operations of Surrey County emergency services.
I believe that thereto does not change the meaning.
Okay.
I think that thereto is just a different way of saying the same thing that's said in the excess parts named insured limitation endorsement.
Okay.
And both phrases are then followed by the possessive of SCES.
Anything else?
I will reserve
Okay.
my time. Well, before I do that, sorry, Your Honor. We made an argument about the volunteer doctrine. As we've said in the briefing, the court does not need to address that issue if it concludes that the AAIC policy does not provide coverage. That only applies if there's some recovery to travelers, and we contend that because of the volunteer issue, we cannot recover the $3 million paid on behalf of Surrey County's liability, because as they've admitted, their policy doesn't cover that. So we would state that if the court gets to that issue, which we believe it shouldn't, it should affirm the district court finding the travelers acted as a volunteer.
All right. Now, I think we addressed the cross appeal. Mr. Michael, I guess. Who's up next?
Yeah.
Mr. Michael.
All right. You got a few minutes if you need them.
I'll be very quick, Your Honor, with 3 points. Excuse me. First point has to do with Mr. Kozlov's statement about there being no direct link between the deaths and the operations of emergency services. That's actually incorrect. The specific protocol that the 9/11 operators were following on the night of the fire, which was inadequate, was developed by the fire marshal, a member of emergency services, and was actually developed by him after 2017 when the two departments were corrected. So there is a direct link between what the 9/11 operators did or failed to do and the provision of emergency services. Mr. Kozlov apparently is now disputing whether the actions of the operators were incidental the district court certainly found that they were, and there was no serious argument below that the actions were incidental. The argument now seems to be that because the arguments were essential and vital, they weren't somehow incidental. The response is simply that the greater includes the lesser. Finally, I would point out that this case boils down to a fairly simple analysis. The question for the court is whether incidental operations of Surrey County Emergency Services and incidental operations performed by members of Surrey County Emergency Services are the exact equivalents. If they are not, then the policy is ambiguous and judgment should be entered for travelers on the claims. Thank you very much.
Mr. Kozloff, you have a couple of minutes, is that it?
Yes.
Okay.
If you just bear with me 1 second, I want to find something to address my friend's last point. His point was that the liability of the county in the underlying case was somehow connected to the conduct of SCES because of the training, excuse me, that was given to the call center. I don't believe that's in the record. I don't believe that evidence is before
I
the court
probably
here.
provoked it because I sort of talked about the dispatching being a central part of the emergency services. And of course, the dispatching might be, and his suggestion was, I mean, there were two functions. One was the counseling of the person called, telling him to close the window and stay inside, or keep the window closed. And the second was the dispatching, but I'm not sure that's material to our analysis at all.
Correct. There was no issue in the manner in which the emergency services personnel was dispatched that caused the unfortunate deaths of the 4 victims. And it's been admitted in the record that the only liability that the county faced was based on the actions of the SCECC call center or the county's training, and none of those were conducted by SCES. And a final point that I'll make, we maintain that the dispatching is not incidental. As the court said, it was essential or necessary, vital. Those are opposites. However, even if the dispatching of SCES personnel by the call center operators is considered incidental, it was not an incidental operation of SCES, possessive, the only insured entity, and therefore not covered under the AIC policy.
Thank you.
And therefore, we ask that the court affirm the district court with respect to the excess policy, excess coverage part, and reverse with respect to the primary. Thank you, Your Honors.
Thank you, thank you. We have battling insurance companies. You guys should really, from my experience, insurance companies usually work these things out in conference, but it's before us now. All right, we'll ask the court to adjourn sine die, and then we'll come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.